My name is Amy Magdalene Matthew.
The question for this assignment is the importance and effectiveness of protecting intellectual property in domain name in Malaysia. Intellectual property. According to a World Intellectual Property Organizations, or known as WIPO, the history of humanity is a history of applying imaginations or innovations and creativity to an existing base of knowledge to solve problems. Both scientific and artistic advancements are fueled by imaginations. Ideas, inventions, technology, work of art, music, and literature are initially intangible but gain value as tangible product are referred as to intellectual property. Intellectual property right. Economic growth, innovations, and competitions have all been greatly impacted by digital age, and intellectual property rights have been crucial in transforming businesses and improving daily life. Technology have become an essential part of people's life due to digitalization, also known as technology integrations. Intellectual property right is the term used to describe the legal protections that are individual inventiveness and creativity as the creator of the product or service are granted, where the creator are granted exclusive legal right over their works of art for a limited time, which enable them to profit financially from their creations. They also have the right to stop the unauthorized use or alterations of their works. Meanwhile, economists view intellectual property right as a policy tool to maintain the market efficiency and competitiveness, encompassing intangible assets like skilled labor, good management practice, customer goodwill, and the right to use and sell knowledge and inventions. Domain name. According to the WIPO, domain names are easily readable internet addresses that are frequently used to locate websites by just entering a website domain name with a unique strings of characters that show up in the browser address bar that allow users to access it directly. Domain names serve as the foundations for additional internet technique or applications like email addresses and file transfer, or known as FTP. There is a global addressing system called the Domain Name System, or known as DNS, where domain names are found and converted into IP addresses. The first come first served policy applies to the purchase of domain names. The owner of a domain name that has been later trademarked keep the rights until they sell it or the registration period expired. From a simple address, the domain name has developed into a valuable tools for retails and e-commercials. It is now comparable to a trade name or trademark for an online business service or product. Businesses can select any domain name that is easy to remember. Usually, a business owner uses their trademark as domain name to draw clients. Trademark. Section 3 of the Trademark Act 1976 defines the term mark to encompass a device, brand, heading, label, tickets, name, signature, words, letter, numeral, or any combinations of these. In the same sections, trademark is defined as a mark that is used or intended to be used in connections with goods or services and a person who is entitled to the mark. It is obvious from the definitions that a trade or business must be connected with the registered mark. Trademarks are used to safeguard a brand identity and prevent consumer confusions. Furthermore, a trademark enables customers to evaluate the product attributes. The balanced trademark protection system enhances the manufacturer market positions and expand the export potentials. This trademark system keeps fake and inferior goods from flooding the market. Also, trademarks are allowed to be used indefinitely as long as they were periodically renewed. The initial period of registration is for 10 years. A trademark owner is granted exclusive right to use the mark. The Trademark Act of 2019 regulates trademarks to stop others from using identical or confusingly similar names for similar goods and services. Next, connection between trademark and domain names. The Malaysia's Network Information Center is the organization responsible for assigning and registering domain names in Malaysia. The Trademark Act of 2019 governs trademark which must be registered with the Trademark Office. Next, both domain names and trademarks are crucial components with distinct functions by communicating brand messages and assisting customers in differentiating between goods and services. Trademarks serve as a symbol of a company identity, reputations, and quality. Conversely, domain names are online addresses for websites that make communications and content access easier. Both components aid in creating an online identity and setting goods and services apart from one another. Both trademark and domain names are distinct entities that can intersect or overlap, but some businesses align them for consistency and brand recognition. However, owning a trademark does not automatically grant right to the corresponding domain name, and domain name registrations does not provide inherent trademark protections. A few common types of domain name dispute have arisen over the year. Firstly, cyber squatting. According to the Cornish and Llewellyn, as e-commerce has expanded, the internet has turned into a virtual marketplace where unfair trade in trademarks, brands, and company name is likely to occur. To a certain degree, the way the system is set up leads to the resurgence of all public confusion risk. Cyber squatting is the act of registering domain name to sell them to businesses for a profit. Meanwhile, typo squatting is an act of registering a misspelled or typographical versions of another person's mark as a domain name in an attempt to catch web users who mistakenly search for the trademark owner address. Next is creating a social media profile under a name of a well-known person in the community. This is to draw in customers because a well-known individual can easily sway others, particularly if they are well-known on social media. Counterfeit products, including a digital content, pose numerous infringement issues as they are often of low quality and sold under another brand name without the owner authorizations. This can lead to the theft of creative efforts and illegal activities. Consumers who buy counterfeit products, include digital content, contribute to financing this activity and to the financing of dangerous and illegal activities. With the growth of online shopping, the problem of counterfeiting on a global scale is getting worse. Furthermore, according to the WIPO, cyber squatting can be defined by three elements, which are the domain name is identical or confusingly similar to a trademark or service marks in which the complaint has a legal rights. Next is the domain name holder has no legitimate right or interest concerning the domain name. And lastly, the domain name has been registered and is being used in a bad faith by aiming to profit from the trademark reputations or cause harm to the trademark owner. Example of cyber squatting is in the case of Skywall Holdings Sdn Bhd and Skywall Development Sdn Bhd. In this case, the plaintiff appealed against the High Court dismissal of their claims for trademark infringements, passing off an unlawful interference with trade, claiming the word Skywall was a prominent feature of the Skywall registered trademark. It was held that the plaintiff is in an infringement actions were allowed to appeal with cause, stating that they could only prove that the infringement name closely resembled the registered trademark to deceive or cause confusions. The defendant were found liable for trademark infringements due to the use of the infringement names in their trade. The plaintiff have presented evidence proving the legitimacy of the Skyworld City Sabah project, that the police were investigating developer activity which were believed to be fraud. The trial judge dismissed the plaintiff claim, stating that the defendant failed to ensure no confusions would arise from the use of infringement names or marks. Petroleum Nasional Berhad against Khoo Ni Keong is the first Malaysian cyber-squatting case where the domain name incorporates the Petronas trademark. In this case, the Petroleum Nasional Berhad, commonly known as Petronas, a prominent Malaysian oil and gas company, discovered that Khoo Ni Keong had registered the domain name petronas.com.my without permissions. Petronas claimed that the use of its name in the domain name could mislead the public into associating the domain with the company, and argued that the domain registrations amounted to trademark infringements and passing off. The High Court ruled in favor of Petronas, finding that the Khoo registrations of the domain name was in bad faith and constituted trademark infringements and passing off. The court ordered the domain name to be transferred to Petronas and recognized that domain name closely linked to establish trademark deserve protections from misuse. It is important to protect domain names in order to prevent cyber squatting. This is because before the brand real trader registers its interest, another party registers a domain name. The registered domain is then sold by the cyber squatter to a trader who wants to use it. On the other hand, a well-secured domain name can enhance the market value of a business, attracting investor and customer. Next, the importance of protecting intellectual property in domain name is brand protections. A domain name is an essential part of the online identity, especially for business owner. Brand recognitions can be ensured with the help of domain name. In the worst situations, customer may have been trouble finding the website if the domain name is stolen. At the same time, domain name protections can help to ensure brand visibility. Maintaining a high level of brand visibility can help prevent the domain name from being stolen or misused. The domain name is often the first impression potential customers have a business. Lastly, domain name can help build customer trust to confidently engage with a legitimate brand. The first effectiveness is a permanent registrations. This way could ensure domains owner maintain their right indefinitely, and a permanent registration system can help lower the chance of losing priceless asset. It could also be enforcing right against cyber squatters that register the domain name intending to sell them at a profit. Furthermore, the legislative framework, as an example of the Trademark Act 2019, where the Act offers a throughout framework for safeguarding domain names that are similar to or match registered trademark. The existence of a legislative framework allows for the punishments of cyber squatters who use domain name in bad faith. Finally, raising awareness among all business owners about the significance of registering trademark related to the domain name may prove to be effective. In conclusions, the protections of intellectual property rights serve as the gatekeeper to guarantee that the protections is provided, especially with regard to the problems of piracy and right infringements. Intellectual property protections in domain name is crucial for maintaining a brand integrity, building customer trust, and ensure fair competitions in Malaysia's digital economy. Domain name can be misused through cyber squatting, typo squatting, and authorized social media accounts that could damage business reputations. Statutory protections like the Trademark Act 2019 and dispute resolutions frameworks like the Domain Name Dispute Resolutions Policy help safeguard digital assets. However, Malaysia's framework faces limitations, including judicial challenges and increasing awareness among small business owners. Continuous improvement of legislative frameworks, permanent registration system, and public awareness incentive is needed.